We're just going to call 23 CRI 043, State of Ohio versus Amado, Herrera, Reyes. Matters before the court for a sentencing hearing. We are conducting that by remote video. However, the defendant and his attorney are present at the courthouse and the court video station. Attorney Jones is here on behalf of the defendant. On behalf of the State of Ohio's Assistant Prosecuting Attorney Mike Callow. Defendant entered pleas of guilty on November 20th, 2023. And I should back up. Mr. Reyes, do you consent to having this hearing by video?
Yes.
I would also note for the record that the Ashland County Prosecuting Office Victim Advocate is also logged in. The defendant entered pleas on November 20th, 2023 to count 1, gross sexual imposition, a felony of the 4th degree, along with the specification for forfeiture of property. Count 3, pandering obscenity involving a minor or impaired person, a felony of the 2nd degree, along with the specification for forfeiture of property. Count 9, illegal use of a minor or impaired person in nudity-oriented material or performance, felony of the 2nd degree, along with the specification for forfeiture of property. Count 13, endangering children, a felony of the 2nd degree. And count 15, tampering with evidence, a felony of the 3rd degree, along with the specification for forfeiture of property. Counsel, I did note the plea paperwork did indicate the defendant, as a result of his guilty pleas, when convictions in the case would be classified as a tier 2 sex offender. My notes were silent as to whether or not I went through that with him before the change of plea. So, Mr. Reyes, I did want to touch on that briefly. Pursuant to 2950-01, you have pled to 1 or more sexually oriented offenses. And by operation of law, you will be classified as a tier 2 sex offender. I will conduct that classification and read that form to you today. But with that classification, you will be subject to registration and verification requirements every 180 days for 25 years. Do you understand those requirements, sir?
I'm reading it now, but yeah.
Does that change your desire to continue with your guilty plea and proceed to sentencing today? I can give you some time to discuss this with your attorney if you'd like.
I'm sorry.
Your Honor, yes, could we have just a moment?
Sure, if you want to go ahead and mute, you can discuss it, that'd be fine.
Thank you. Thank you, Your Honor.
Thank you.
We're ready.
Okay, and we're still on the record in the Reyes case. Mr. Reyes, you've had the opportunity to discuss the sexual oriented offense registration with your attorney. And for the record, as I said, it was contained in the plea paperwork that was signed by the defendant. Having discussed that with your attorney, do you still wish to proceed with your guilty plea and sentencing today?
Yes, sir.
Ms. Jones, did you receive a copy of the pre-sentence investigation?
Yes, Your Honor.
Mr. Callow, did you likewise?
Yes, sir. Thank you.
Ms. Jones, is there any reason that sentencing should not proceed today?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
Your Honor, we would rely in large part on our filed sentencing memorandum, in particular with our request for a minimum treatment-focused imposition of sentence today. And I do know that my client has prepared a statement and would like to speak to the court.
Reyes, you may proceed.
Oh, I'm sorry, Your Honor. It's tucked into his Bible, which is in the hallway. Would the court allow me one moment to go get it?
Sure.
Apologies.
Okay. Your Honor, I stand before you and in court today with yeah. With a heavy heart full of awareness of the gravity of my actions. I want to express my deepest and sincerest apologies to all who I offended and affected. I take responsibility for the pain and hardship that I've caused. I understand the consequences of my choices and the impact they have on the lives of others. Second here, okay. Okay. I am committed to use this time in custody to reflect and learn and grow as an individual. My goals are to engage from this to emerge from this experience as a better person, ready to contribute positively to society. I appreciate the opportunity to address the court and humbly request forgiveness from those who I've wronged. Thank you.
Mr. Reyes. Mr. Callow, anything on behalf of the state?
Judge, it's my understanding, first of all, before the state makes its position known, that there is victim and victim's family with the victim advocate on video. It's my understanding they do not wish to make an additional statement. But Judge, as is my practice, I'd ask for 30 seconds in case they change their mind, that they could turn the camera on and make a statement, but they certainly don't have to. But it's my practice, Judge, and I know you typically let me to have 15, 20 seconds so that they can make that decision. Is that okay with you?
That's fine by me, Mr. Callow. Given the age of the victim, I'm not going to require her to turn the video on. If she just wants to turn the audio on, she can do so.
Okay, Judge, if we can just give a few seconds for that, thank you. Judge, it would appear that they are going to remain with their decision to watch and not give a statement. Judge, therefore, the state will move forward. A couple of things, Judge, I would highlight for you the victim statements that are in the record and incorporated as part of the PSI. Judge, I know you've read them. You're always very prepared. I won't read those and I won't highlight those to you, Judge, except for to indicate that the state was very moved by the expressions by the victims and the victim's family in this case, and that We, of course, Judge, think that this behavior warrants an extensive prison sentence in this case. Judge, the idea of a treatment-oriented probation would be highly unreasonable and unlikely in this case, Judge. The case had numerous charges, Judge, as you highlighted. In the end, there was a plea agreement reached with 5 counts. Judge, the state's position is that each of those 5 counts requires, not mandatory, but we believe the nature of those counts would require a prison sentence, Judge. We would indicate that we think that each of those 5 counts require a separate and consecutive prison sentence, Judge, due to the extreme seriousness of the conduct in this case. Judge, you will remember the process that this case played out, which includes a mental evaluation and some additional reports that you were able to review at previous hearings, Judge. I would ask you, and I'm sure you've reviewed those, I'd ask you to take into consideration the renditions and versions and explanations that were given by the defendant for his conduct. Judge, they were scary. They were threatening. Judge, they indicated to us some of the most demented conduct that we can think of recently for violating and doing this type of sexual behavior to a child. And then we think that he is absolutely a danger to anyone else, any children, particularly his own children, and anyone else in the community. Judge, the state of Ohio would be asking on each of these 5 counts for a prison sentence. We do not think that any of these counts would be appropriately punished with a minimum sentence. We do not think that any of these counts are mergeable or similar conduct. So we would be asking for a non-minimum prison sentence on each offense. We'd ask that you run them consecutive to each other. The judge, on count 1, which is a felony of the 4th degree, we would be asking and recommending to the court a 1-year prison sentence. That is a non-minimum prison sentence, not max, but non-minimum. Judge, on count 3, which is a felony of the 2nd degree, we would be recommending to the court a 6-year prison sentence. Judge, on count 9, which is a felony of the 6th degree, we would be recommending the court a 6-year prison sentence. On count 13, which is a felony of the 6th degree, we'd be recommending the court a 6-year prison sentence. All 3 of those, Judge, are non-minimum, however, non-maximum prison sentences. And on count 15, again, separate criminal behavior, Judge, felony of the 3rd degree, we'll be recommending to the court a 2-year prison sentence, not the minimum, not the maximum. Judge, we would be asking you to run each of those sentences consecutive due to the criminal behavior in this case and to protect the victim and protect our community. Thank you. Judge, may I also add, I forgot that I would ask you to order forfeitures as described in the indictment. Didn't want to leave that out. Thank you, sir.
Thank you, Mr. Cowell. Court has gone back through this case, reviewed the case history, reviewed the pre-sentence investigation from Mr. Niedermeyer, which doesn't indicate an ORS score of 9, being low. I've considered statements here of counsel and the defendant. I've also reviewed the sentencing memorandum filed by the defendant and the letters on behalf of the minor victim. Mr. Reyes, I'm going to just start with the sexual offender registration. You have that form in front of you, is that correct?
Yes.
All right, I'm going to read that to you. You have been convicted or pleaded guilty to a sexually oriented offense or child victim offense as defined by 2950.01 of the revised code, and you are hereby one of the following: a tier 2 sex offender, child victim offender registrant. You are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You are also required to register in person with the sheriff of the county in which you establish a place of employment if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residency or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. Employment includes volunteer services. You are required to provide the sheriff temporary lodging information, including your address and length of stay, if your absence will be for 7 days or more. After the date of initial registration, you are required to periodically verify your residence, place of employment, and/or place of employment in person in the county sheriff's office no earlier than 10 days prior to your verification date. If you change your residence, address, place of employment, or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside or establish a place of employment and/or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the resident address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address. You must register with the sheriff at that fixed address. You are further advised in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to criminal prosecution. You should provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you have most recently registered. And you are going to be tier 2, which means for a period of 25 years, you are to register in person with verification every 180 days. The address is left blank in paragraph 9. Paragraph 10 says that failure to register, failure to verify residence at these specified times, or failure to provide notice of change of address, change in resident address, or other required information as described will result in criminal prosecution. Paragraph 11 says, I acknowledge that the above requirements have been explained to me and that I must abide by all provisions of the Ohio Revised Code, Chapter 2950. So Reyes, if you could sign that line above offender's signature, that's just verifying that I have read and explained those to you.
Your Honor, would you like us to sign both copies?
Yes, please. One will be for him. All right, have you done so, sir? Are the forms signed?
Yes.
With respect to merger, the court is finding that these counts do not merge. Specifically with respect to counts 3, 9, and 13, case law, I think, would support that. We have multiple images taken. The pre-sentence investigation references 10. Case law has said each image is different, requires a different decision from the defendant. Further, the image referenced in count 3 is a different image from the one referenced in count 9. Count 9 simply references photographing the child in the nude. Count 3 references creating obscene material with a minor participating. The pre-sentence investigation did reference specific photos containing different acts, including manipulation of the labia of the victim, as well as side photos of exposed breasts. Count 13 deals with permitting the child to be photographed in any material that was sexually oriented or nudity oriented. So I am finding different animus for these acts and finding that they should not be merged. With respect to the statutory guidance, the court has considered the purposes and principles of felony sentencing, including 29-29-11 and 29-29-12, as well as the relevant serious and recidivism factors. I would note at the outset that there is a presumption of prison, that a prison term is appropriate sentence for counts 3, 9, and 13. To rebut that presumption, a court must find that non-prison sanctions would both adequately protect the public and punish the offender, because the factors indicating recidivism is less likely outweigh the factors indicating recidivism is more likely, and also find that this would not demean the seriousness of the offense because the less serious factors outweigh the more serious factors. As set forth in the pre-sentence investigation, the court would note that with respect to recidivism, the less likely indicators are more than the more likely recidivism indicators. You present with no prior record, you have no substance abuse profile, your ORAS score is low. However, the court would note there was a bond violation in this case. I also disagree with the findings set forth in the pre-sentence investigation that the suggestion was that this was committed under circumstances not likely to reoccur. I'll expand on that in a moment. Court would also note that you did enter a plea and you did spare the victim the psychological impact of a trial. But in return, you also had multiple charges dismissed, including 1F4, 1F5, and 8 F2s. So you have considered or received a great deal of consideration from the state of Ohio. But when I look at this, the less serious factors do not outweigh the more serious factors. And that really is the issue here. Seriousness and the impact of these crimes to the victim. The pre-sentence investigation indicates 4 factors that make this offense these offenses more serious. It does appear from the sentencing memorandum that your counsel takes issue with the suggestion that a position of trust was related to the offense. I have reviewed the case law, and I believe that this factor is indeed present. You were the stepfather of the victim. Family placed you in a position of trust that facilitated these offenses. But even if that was removed, the seriousness factors still outweigh the less serious factors. I would also note there was an argument that you didn't expect to cause physical harm in mitigation, that there exist grounds for mitigation. The court's not convinced that either of those are present. Specifically, physical harm to persons means any injury, illness, or other psychological impairment, regardless of gravity or duration. I think that's certainly in play here. With respect to grounds for mitigation and really with respect to accepting responsibility and remorse, the court likewise has a lot of concern there. The court would note that you indicated to officers, and you also indicated during the NGRI evaluation that a voice in your head made you do this. Your uncle's voice made you do this. However, that didn't appear to be supported by any evidence here for several reasons. First, you were not forthcoming with officers when they first interviewed you. Your story evolved from it being possible that you grazed the buttocks of the victim when you covered her up with a blanket, and that it was accidental. It then evolved to you denied touching her vagina, but you did admit to grabbing her buttocks. That was apparently for the first time ever when you told the story of hearing voices, and you did admit to grabbing her buttocks with 2 hands and then pulling away and feeling terrible about it. Court would note that that kind of mental illness was never observed, apparently, by anyone that lived with you. You've apparently never treated for it before. But what makes that story even less credible, in my view, is the fact you had photos on your phone of these acts. Photos that you didn't delete until one day, or until the day the officers talked to you. But they were created at least a year prior to that. So that is certainly inconsistent with your version of events. Also, this is not an isolated incident. This, according to the victim, went on for years, started when she was 10 or 11 years old. Court would note there was also mentioned in the PSI that there was pornography that was depicting young individuals that was turned over to the police. So I do not believe that this was caused by voices in your head. I think you made repeated decisions to act in this manner, and then you tried to come up with an excuse to get out of it. But when I look at these offenses, you were certainly in a position of trust. You took advantage of a young child when she was asleep, who by all accounts viewed you as a father, not a stepfather. Then the court looks at your statement in the pre-sentence investigation and you say, quote, "I'm still a loving father, brother, son, and friend, a protector, a provider, a man with Christian values." I can't even fathom how you would still consider yourself to be a protector. I mean, you were supposed to be a protector. You were supposed to be a hero to that little girl. But you disregarded that duty, and in turn, you created what could be a lifetime of pain for this child. You referenced your own history and difficulty. That cuts both ways. You should know about the lasting effects something like this could have on a person. So you were not a protector of this child. You were a predator of this child. And the fact you do not see those concerns, or the fact that you don't see that, concerns this court that these are circumstances that very well could reoccur. But at the end of the day, you've taken an innocence away from this child. A simple thing like a hug. She's no longer comfortable being hugged. She's always scared, and this is something that she's going to deal with probably for the rest of her life. You also, in your pre-sentence investigation, you indicated you wanted to help other fathers fight for their rights and put an end to parental alienation. Mr. Reyes, you should never be around another child again. The court is finding that community control is not mandatory, that you are not a candidate for community control, and that it would be demeaning to the seriousness of these offenses. Further, I am finding that the presumption for prison is not overcome with respect to counts 3, 9, and 13. Even if it were, I am finding that prison terms are consistent with the purposes and principles of felony sentencing. I would also find that the seriousness of these offenses remove them from consideration for minimum terms. In fashioning a sentence, the court is required to look at each count individually. That is what I'm going to do. With respect to count 1, gross sexual imposition, this conduct was repeated, it was completely unwanted, and it has caused immeasurable harm to the victim. Court's finding anything less than a maximum sentence would be demeaning to the seriousness of your conduct with respect to this offense. Therefore, the court is ordering that you serve 18 months, the maximum sentence for this count, at an appropriate penal institution. With respect to count 3, pandering obscenity involving a minor or impaired person, you took a photograph of an obscene act involving you molesting this child. So not only did you commit the act, you photographed it, and then you stored that on your phone for a significant period of time. I can't find a more serious version of this offense, and anything less than maximum sentence on this offense would be demeaning to the seriousness of your conduct. Therefore, the court is ordering you to serve a minimum term of 8 years for count 3, which makes the maximum term 12 years in an appropriate penal institution. With respect to count 9, again, illegal use of a minor or impaired person in nudity-oriented material or performance. You photographed this child in a state of nudity while she was asleep. That is an incredibly serious offense. It was done without her knowledge or consent, and while she was sleeping and vulnerable to you. Court is ordering that you serve a period of 6 years in an appropriate penal institution, which is the minimum term, making the maximum on that count to be 9 years. With respect to count 13, endangering children, again, as a count, I think encompasses more than just the 2 specific charges. It speaks to the repetitive nature of this offense. Again, the court finds this to be a serious offense and is ordering you to serve 6 years in an appropriate penal institution for the minimum, which will make the maximum on that count at 9 years. With respect to count 15, it's clear to the court you deleted these photos after speaking to the officers. It's also clear to the court that they were recovered by dumping your phone and looking in your trash. Court's going to order that you serve 30 months in an appropriate penal institution on count 15. Now, with respect to consecutive versus concurrent, court is finding it is necessary to punish the offender and protect the public from future crimes and not disproportionate to the seriousness of the conduct and the danger posed by the defendant. With respect to counts 1, 3, 9, and 13, I am finding that those offenses were part of one or more courses of conduct, and the harm caused is so great or unusual that a single prison term would not adequately reflect the seriousness of the conduct, and therefore I'm ordering those terms to be served consecutive to each other. With respect to count 15, the court's not able to find that the harm justifies a consecutive sentence. Therefore, I'm ordering that count 15 be ran concurrent. Therefore, the total minimum term that you are facing is 21.5 years. Pursuant to Reagan-Tokes, the maximum, the longest minimum term for which the most serious offense is 8 years, and count 3, making the maximum for that term 12 years or an additional 4. Therefore, your total sentence will be 21.5 years minimum, making your maximum 25.5. It is presumed under Reagan-Tokes that you'll be released at the end of your minimum sentence. If you're not released at the end of your minimum sentence, all release decisions are made by the Ohio Department of Rehabilitation and Corrections. They can rebut the presumption that you're released at your minimum sentence by holding a hearing and making specific findings outweighing your release. This process can happen multiple times. Ultimately, if you've not been released prior to the expiration of your maximum term, you would then be released. You will be subject to a post-release control term of a mandatory 5 years following your release from prison. If you violate post-release control, the parole board may impose a prison term for a rules violation. In 9-month increments, they can send you back to prison for up to 9 months at a time on a rules violation, not more than 1/2 of your originally stated term for all violations. Additionally, if while on post-release control, you're convicted of a felony, in addition to your sentence on that new felony, that court will have the authority to terminate your post-release control and order a consecutive prison term of up to 1 year or the time left on post-release control, whichever is greater. That will be on top of or in addition to, consecutive to any new prison term on a new felony. You do have 57 days of jail time credit as of today. You will continue to earn jail time credit until you're transported to the Ohio Department of Rehabilitation and Corrections. Given the length of incarceration, the court is not ordering fines in this matter. However, based on the facts and circumstances in the pre-sentence investigation, I am finding you have the future ability to be employed and pay court costs in this matter, and I am assessing court costs to you. Court is also ordering that the smartphone, Solero 5G smartphone referenced in the indictment is forfeited to the state of Ohio. Mr. Reyes, you do have the ability to appeal my decision. Any notice of appeal must be filed within 30 days of my sentencing entry. If you're unable to pay for the cost of a transcript, the record, or any relevant documents required for an appeal, those can be provided to you without cost. If you're unable to obtain counsel for an appeal, including to file the notice of appeal, counsel can be appointed at no cost if you are indigent upon your request. Mr. Callow, anything further?
No, sir. Thank you.
Ms. Jones?
Not at this time, Your Honor. Thank you.
All right, the pre-sentence investigation victim impact statements will be filed under seal in this matter. Any bond conditions will be released upon the journalization of my judgment entry. Mr. Reyes, you are remanded to the sheriff for transport to the Ohio Department of Rehabilitation and Corrections. This matter is adjourned. Thank you.